18 after 7, good to have you with us on the midweek edition of the South African Morning. The lack of access to justice is a stark reality faced by many South Africans. Endless postponements and lengthy delays are a common problem, especially in criminal cases, especially of those in the lower courts as well. But we've seen, as we cover these cases over the years, how often they can be delayed. Now, the delays often give rise to frustration among all the parties involved and their families. So what exactly takes so long? I know it's an obvious question, but it's one that we've seen many people complaining about as we cover various high-profile court cases in our country here. Well, Melusi Xulu from Donda Attorneys joins us this morning. Melusi, good to have you with us. And I know it seems like an obvious question, but I can't help but think maybe there's an understanding or a lack of understanding by the public on why the wheels turn so slowly. Is it slow, or is it just because we're not involved like an attorney is?
Good morning, Garrett, and viewers at home. Look, let me start with what is stated in the Constitution. Section 35, subsection 3, paragraph D. It says that a trial must begin without any delay for the accused. The accused has that right. But there are a number of reasons why a trial will be delayed, why it will begin late. For example, it will depend on the complexity of the case. Maybe it's a financial crime and there are many experts that are needed. It can be for the fact that there's DNA evidence that needs to be obtained, which can take time at the lab. And it can be the fact that there are no witnesses involved. So there are a number of reasons why a trial will not begin in time. But should it not begin in time, there are solutions in the Criminal Procedure Act, which I will state later on in Section 342A of the Constitution, where a matter can be struck off the roll if it's unreasonably delayed.
I suppose the problem is, though, as you talk about that piece of legislation, when we watch high-profile court cases, for example, the Thabo Bester court case, the Senzo Mayiwa court case as well, and we constantly see new witnesses being brought in, we constantly seeing new evidence being introduced as well, and these can run on for years, especially the Mayiwa case, just to use that as an example as well. What is the point, and who makes that decision that it is now becoming fruitless, and it's now not in the interest of the accused to carry on with the court case? Who makes that application, or is that left to the judge or the magistrate?
It's the magistrate that decides. For example, in 342A, it stated that if the delay is based on the fact that there's one of the people in the case that are making the case to be delayed, it can look at the fact that is it because of the investigation. I'll just make an example of a case that I'm aware of, where they want to get a handwriting expert for a certain witness, and it's taken about 6 or 7 months. So that becomes an unreasonable delay. So once the magistrate sees that the investigation or whatever delay is causing the matter to be unreasonably delayed, he will make an order that the case be struck off the roll. And then it will be struck off the roll. And the only time it can come back to court is when the Director of Public Prosecution gives a written permission that it can start and it can be brought back to court. So it's the court that decides if it has been unreasonably delayed. That is according to Section 342A of the Criminal Procedure Act.
I've always been curious, from an attorney's perspective and a lawyer's perspective, appearing in court, whether it's the prosecution or the defense. We often see viewers on social media reacting, saying that they're playing delay tactics by wanting to change their legal counsel. They want to have a witness come in, but that witness isn't available for, say, 3-4 months from now. Why does it always appear, and I'm not attacking the judiciary, please don't misunderstand me, why does it always appear that the courts give in to that, as opposed to what we were saying earlier? It's up to the judge or the magistrate to put his foot down, his or her foot down, and say this is not good enough, we're continuing. I suppose the argument comes in, it's the justice for the accused, or it's the time of the court. How do you think that should be balanced?
There has to be a balance. For example, I'll just quote or paraphrase what was stated in Zepa versus the DPP. It was stated that there must be fairness for the accused, and there must be also public confidence in the criminal justice system. But it must also look at the fairness for the people that are affected by the crime. So when the judge or the magistrate decides, they need to look at all those factors. They can't only decide only for the accused. They need to have a holistic approach as to what is the fair reason for postponement. I think the case that is obvious that we can discuss is one of the former presidents, former president of South Africa, President Zuma's cases, where there are a number of applications that is bringing, and some of them they bring him for his own good, but some of them they may be viewed as unreasonable delays. So that is where they bring in the Stalingrad defense, where they say this is where the accused or the defense bring every reason to delay the matter and to bring pressure on the prosecution, and the case ends up not proceeding as soon as it can. So sometimes the accused can use that in an unfair way, if I may put it like that.
No, sure, and I think you've taken the words out of my mouth. I was going to ask that as my next question, as an obvious example, because right now, I think those who aren't following the arms deal court cases and the various applications, I'm curious, in a situation like that, and we don't have to go into details of it because I know that you're not involved necessarily with it, can a judge or a magistrate or a court see that these are deliberate delays by the defense in a case like this? We can talk about the Zuma court case if you'd like to, but use it as an example. Can they see that this is an obvious and deliberate attempt to delay court cases, and what can a judge or magistrate do about that?
Look, the court obviously has a discretion to decide on the matter. So once they see that an accused or the defense is bringing maybe reasons or applications which are not, making any reasons from a justice perspective, they can decide based on Section 342A. It's a very important section, and they can decide that no, this is unreasonably delayed. The matter must continue, or the matter must be struck off the roll. It will depend what they decide then. But once the matter is started, for example, once the matter is started, the witnesses have been brought in, the court can decide that for whatever reason the defense wants the matter to be postponed for. If the reason is not making sense, they can decide that the matter must. Obviously, the reason why, Gareth, maybe the judges or the magistrate will be careful in such situations. These things may make reasons, or these acts may or orders may make reasons for the matter to be appealed or reviewed. So when they make the decisions, they must make sure that the decision is a fair decision, whether they're saying the matter must continue or that they're saying the matter must be struck off. So it's a very important decision, but also they must be careful when they make them, because they may be taken on review and appeal.
Yeah, no, I understand. I want to just ask a last question because I have this story next, and I just want to just create some context for viewers and myself even on this. If we're talking about the Thabo Bester case, again, you don't have to talk to the case itself. I understand it is sub judice, but as an example, 3 more suspects have been arrested. I think we're now up to a total of 12 people arrested in this particular court case. How does that influence how quickly a court starts getting through the work of administering justice? Does a court now have to wait for every possible suspect to make an appearance in court? That could be hundreds of people. Or does the court start with the court case with each individual person and just start adding in new witnesses? Or is the court going to wait until the state, I imagine in this case, is happy with the number of witnesses they've got? Because this seems to be taking a very, very long time. It's difficult to keep up sometimes.
Gareth, the Thabo Bester case is a very complicated case, as you can see. I think I've been on record to say I believe there are high-profile people that could or should be arrested. But having said that, the state can always, if there's unreasonable delays, they can always separate the cases. It's there in the Criminal Procedure Act where they can say one of the accused or a number of them, a matter can begin. Say, for example, I'll give a very practical example. Say maybe of the 12 accused, one of them is sick and is very sick and he cannot attend court. They can decide to separate the case and continue with the 11 so that the matter is not delayed until an undetermined period. So those are there.
Okay, I see. I think you've clarified a lot for me, because it just occurred to me now we are showing the visuals of the Thabo Bester case, and it's a story we're going to be following because of the 3 more arrests, and I was curious to get your thoughts on that. I think you've clarified a lot. So justice delayed, not necessarily justice denied, if not abused, however, is my takeaway. Melusi, thank you very much. I'm sure you and I will talk again in the near future. Fascinating.